please mention on the chat box where are you from, what are you doing, and your reason for joining the webinar. We'd love to know you all. Aarti, Aryan, Ashish, Ashwin, I can see so many of you here. Thank you so much for joining, guys. Hargovind, Gyan Raja, Gunjan, Himanshu, Hitim, Ishan, Kasif. Catherine, Khushi, Kunal, Likhit, Likita, Madhi, Mehak, Mansi, so many of you all. I can see Rishita is from Chandigarh. Uh, Anjali is a law graduate here. Averi is from Shimla, Noida, Pune. Thank you so much, guys, for joining in. Thank you so much for joining in, guys. We have Vijayanand from Lucknow, Shobna from Delhi. Aditi here is the first year law student. That's very interesting. Thank you for joining in, guys. Yash is from Pune. Great. That's amazing. Okay. Thank you so much. I think we can start the webinar now. So, hello everyone. I am extremely delighted and extremely elated to welcome you all to today's webinar. I'm Samiksha Singh. I will be your host and moderator for today's webinar. I am a criminal litigator and I'm practicing across the courts of Chhattisgarh. Prior to this, I was associated to the chambers of Advocate Yugmohit Chaudhary and Satish Manishinde in Bombay. I graduated from HNLU in 2019 with a specialization in criminal honors and trade and investment. Post that, I went on to do my LLM in criminal laws, and I'm currently pursuing my PhD in the allied laws as well. So I've always been inclined towards teaching and education, and hence I joined Lawctopus Law School's team, the reputed team, as a learning manager, and I'm also the faculty for the criminal drafting course here. So in case you do decide to join us at a later stage, mine will be the face you will be dealing with on a weekly basis. So criminal laws are the fundamental cornerstones of the society. With the introduction of the new criminal laws, there are so many more questions than the answers themselves. Today, we will embark on this journey to understand these significant legal changes in a society, which is extremely important for us, and we will do so in a very clear and a straightforward manner. Now, these laws are going to significantly impact our society in various ways, and which is why it's extremely crucial for us to grasp the implications that it withholds. So, this masterclass is basically designed to break those complexities down for you, making it accessible for all of you to understand what the new changes in the laws are by demystifying the air around it. So by the end of this session, I really do hope that you will not only have a better understanding of these laws, but you will also become appreciative of their importance in our daily lives. So discussing and understanding this issue is extremely vital, as it will empower you as an informed citizen who wants to navigate and influence the legal landscape effectively. So today's session is going to flow in the following manner. From about 7:10 to 8:10, we shall be discussing the introduction and overview, and we'll be taking you through the brief history of criminal law in India, as well as the overview of the 3 new criminal laws. Post that, we will be breaking down and making an analysis of the new laws by understanding the key changes and their implications. We'll also go through the new categories of the substantive laws that have been added or substantially modified in the new laws. Post that, we'll be talking about the comparison between the old laws and the new laws, and then we'll be talking about the practical implications of the same. Moving forward, we'll also be speaking about implications and impact on the legal practice and the law enforcement agencies as well. We'll talk about change in the core procedural aspects, for example, complaint cases versus police cases. We'll also talk about case studies and real-world examples by also discussing the potential challenges and solutions. Then we'll move forth and discuss new case laws and committee reports, which are extremely important for us, by concluding the session and taking away what's important here. Post that, from 8:10 to 8:30, we will have a Q&A session with our expert, who I'll shortly introduce and I'm extremely elated to have. Then from 8:30 to 9 p.m., we shall have a bonus registration opportunity at the Lawctopus Law School. Now, I encourage you all to engage actively, during this webinar. Ask as many questions as you can. Share your thoughts. Network with your peers. This is a fantastic opportunity to learn from the expert as well as connect with like-minded individuals who share your passion. So once again, thank you so much for joining us. We are extremely excited to embark this journey and hope by the end of this session you will take something very valuable away. Now, I'm extremely excited to introduce to you our speaker for today, Advocate Nipun Saxena, who is a practicing advocate at the Supreme Court of India and also takes up matters in various high courts through India. Now, in legal fraternity, Nipun sir needs no introduction at all, but it still gives me the pleasure, to talk a little about his work profile. He is an alumnus of the prestigious National University of Delhi, and he has authored and contributed to various international and national publications of repute, and has also worked very closely with the criminal justice administration reforms. Nipun sir also is associated with the Additional Solicitor General of India and has worked extensively on landmark cases. Advocate Saxena also frequently advises individuals and body corporates, companies, civil societies, firms, and associations on litigation strategies, critical legal issues, documentation, conveyancing, and general legal counseling, and renders his opinion on various legal matters, and is also a host and is also a speaker at many, many webinars and talks such as this one. I'm extremely excited to have you here today, sir. And without any further ado, I'm handing the session and I'm handing the stage over to you. All yours, sir.
Thank you so much, Samiksha, for this wonderful introduction. And might I say it's understood? I don't know how whether I will be able to, in fact, some justice to the discourse today. But the way I wish to and propose to deal with it is in a threefold manner. First, we shall take up DNSS.
Sir, your audio is not quite clear. The voice is vibrating. Yes, sir.
Am I audible now? Is it better?
A little better, yes.
A little better. Just give me one.
Much better now.
Acha, okay. Is it?
Yeah.
What I can do is I can shift this laptop slightly so that.
Okay.
Is it better now?
Yes, much better, sir.
All right,
Yeah.
very. So, okay. So the manner in which I propose to deal with today's session is by introducing our audience and our viewers and our listeners to the three laws, right? We will first go back in time to the history of the laws, how exactly criminal laws find their place in the republic that we live today. What were the predecessor legislations? What were the changes that were made to the laws that existed at least until 1st July 2024? And thereafter, what are the new laws that are, right? In the second part, what I'm going to do is I'm going to deal with certain problematic areas which are there in the law and what are the issues and the challenges that may arise. And thereafter, we shall also discuss how the laws could have been drafted slightly better, right? Or the way forward as to how exactly we could have eliminated any sort of confusion or vagueness in the laws as it may have, crept in, despite the best efforts of the legislature, I give it to them. All right. So that's how we propose to begin. 1830 is the year that comes to my mind, when a certain person was allocated and entrusted with the task to set up a committee to study the laws that were to apply to the dominion of India. At that point of time, it was called the British India. The man who was entrusted with that job was Lord Macaulay.
Sir,
Yeah.
so sorry to interrupt, but your voice is not clear. Can you just speak a little?
Okay. Is it better now? 1 second. Is it better this way?
Yeah, it's better.
Yeah.
Yes, yes.
It's
Yes.
much better. Yes,
Much
sir.
better. Very
Yes.
well. I'm
Yeah.
so sorry. Okay.
Yeah, no problem. Thank you, sir.
Okay. Yeah. So I'll begin again. So in the year 1830, there was a gentleman who was entrusted with the task of laying down what you call the laws for the dominion of India, right? Now, this particular gentleman was, of course, a British lord who was conferred with lordship much, much later, but he had done exceedingly good job and he was out and out a researcher, right? And therefore, this particular gentleman was sent to India on the special instructions to study the law and to give his suggestions, right? And that particular person, of course, yes, Ritika, he's called Lord Macaulay, who was then entrusted with the task to draft something, right? But before you do draft a law, you have to understand the people. You have to understand, as he called them, the natives, right? Because until that time, the law that was to apply to the natives that were living there were very differential. Right? Now, when I say differential, what do I mean? I mean that their religious laws took precedence over the criminal laws that were to apply. So therefore, for a dispute, or let's say if an offense was committed by a Muslim against another Muslim, the Muslim law apply, right? Similarly, if an offense was committed by one Hindu against another Hindu, the Hindu law would apply, right? And there were laws which governed even these aspects, right? So there was a criminal Hindu law and there were criminal Muslim laws which applied, right? And the biggest problem with these laws were that they applied to their own territory to which the kingdom, ruled, right? So the king had a certain territory over which that particular law applied. There were conflict of laws because what happens in a case, let's say, where one person from a religious community enters into another territory and commits an offense, who then which law were to apply? So that conflict of laws, as we study in modern discourse, was also something that used to perturb the kings at that point of time. With the British Dominion making its foot deeper into the territories of India. When they first started, everybody knows those 7 islands of Bombay were given. Thereafter, by way of the Charter Act of 1861, Calcutta was established. But much before that, there was also Madras Presidency, which had a regulating act of 773, and the ones which even preceded before that. There was something called an old town and a new town. And one of the biggest problems with one of those laws to apply was, say, the inner town. It's interesting because the inner town was governed by the European laws, because inner town of Madras at that point of time, now Chennai, was only open to the European natives or the Anglo-Indians who used to reside there, right? So suppose an Anglo-Indian were to commit an offense against a native which is living outside the boundary walls of that inner town, then which law were to apply, right? So therefore, various aspects were sought to be ironed out, creased out. As the British grew a stronger foothold, there was a need to ensure that there is one law, a uniform code, which was to apply to everybody across, irrespective of their caste, creed, religion, right? And therefore they came, and therefore they entrusted Macaulay with this humongous uh, responsibility, because you would do well to visualize that the India of that time was an undivided India. It went to Broch, Kandhar, right up to Ceylon. On this side, it went up to Myanmar, and it crossed even further, right? So therefore, the law that was supposed to be drafted was supposed to be the law which will apply across the board, right? And at that point of time, I mean, if statistics were to believe, it had an application over 30 million people back in those days, right? So it was, the territories were huge, the dominion was huge and ever growing, and Macaulay had absolutely no idea how to begin the entire exercise. So when he sat down, it took him over 30 years, from the year 1830 till the year 1860, that Macaulay first came out with what you call the first piece of substantive law, right, which is the Indian Penal Code. Thereafter, Lord Macaulay also sat down and drafted the second piece of legislation, which is from 1860 till 1872, which took him another 12 years, which is what you call the Indian Evidence Act, right? And thereafter, from 1872 till 1894, which is another about 18 years and odds, it took him to draft what you call the Code of Criminal Procedure, right? Now, 1830 till almost 1894 was the entire time span that it took for him to enact these legislations, right? Of course, it was a lifetime of work, as you can understand, right? And thereafter, all those legal provisions came to be enacted. Now, of course, going that was also a whirlwind of change, as you would call it, right? Because somewhere, if you were to say, India had a very dynamic governor general in that point at that point of time, the dominion of India. I'm not talking about India, the dominion of India, right? William Bentinck was also one of those persons who was also responsible for bringing what you call very progressive legislations, like the Widow Remarriage Act, the Sati Prohibition Act, right? Both these laws were of the year 1872 and 1876. I'm largely speaking from memory, so please pardon me if I get 1 year here or there, but by and large, it is what it is, right? And you would also see a lot of socialist reformist movements which were going on. You had a Raja Ram Mohan Roy's movement going on, Henry L. Derozio, and all these social winds of change were very instrumental in devising the laws that you have today, right? We also come to learn that the position of women and children aged was extremely deplorable at that point of time in history, because women historically were dependent economically and otherwise on their husbands, right? Or their fathers. And therefore, they were treated, today's day and age, we may not agree with it, but at that point of time, they were treated as a special. All right, recording is in progress. So yeah, those were treated as a special category of individuals for whose benefit and for whose sake certain laws were devised, right? So there, you would find many provisions at that point of time which were specifically earmarked for women, children, and the aged, the infirm, right? So with all of that, we come to 1947, right, when India gains independence. By that point of time, you would see that many Commonwealth nations had in fact adopted the Indian criminal laws as were devised by Lord Macaulay, right? The criminal law of Ceylon, most of the provisions in Hong Kong, Nepal, Bhutan, Bangladesh, as recently as now, has also taken substantial provisions. In fact, even the Pakistan's code of substantive and procedural criminal law has a very heavy bearing on what it was. Now, one would imagine that, say, Afghanistan to other places where, or Myanmar, all those regions till date are governed by substantially similar laws. Okay? Now, what happens is in the year 1947, when India gains independence, the first time that the Law Commission actually sits down to do a review of the laws in order to do away with the communal, or the, sorry, not the communal, but the colonial heritage, was when these law commissions were set down, right? The 31st, 35th, 37th, 41st Law Commission reports set down extensively from 1961 till the year 1973. In fact, 41st Law Commission is very interesting in that sense because it is divided into two volumes. That particular Law Commission exclusively devoted all its time to CRPC, right? And therefore, they changed, or, the criminal laws had a revamp of sorts. So IPC, CRPC, and Evidence Act was substantially modified through Criminal Law Amendment Acts. Once those Criminal Law Amendment Acts gained a foothold, it is then that you had the present laws in their shape and form, right? Only the year of enactment was 1860 or 1872. Most of the Law Commission reports which submitted their copious reports were accepted by Indian parliaments, which enacted what you call Criminal Law Amendment Acts, right? And therefore, by the time it was 1973, you had a completely Indianized version of the criminal laws. So what were those changes? Of course, they were very simple cosmetic changes like changing British dominion to the territories of India, right? There were even more substantive provisions which were changed, say act done against the king, right? Or attacking one of the ministers, etc. All those provisions were done away with, right? To have what you call a more republican view of things, right? When the laws came into picture. So that's the history of it. Now, what happens is, we all know that sometime about a year and a half back, there were various changes which were brought in by way of these new criminal laws, which were tabled on the floor of the parliament. Right? We have the Bharatiya Nyaya Sanhita, we have the BNS, which is the IPC successor. We have the Bharatiya Nagarik Suraksha Sanhita, right, which is the BNSS, which is the CRPC successor. And we have the Bharatiya Sakshya Adhiniyam, right, or the successor to the Indian Evidence Act. Now, all these three laws were passed before the House of Lok Sabha, Rajya Sabha. They received the presidential assent, and on 20th December 2023, they came in. They received the presidential assent. Right now, the date of coming into force, as per Section 4 of these laws, was held to be 1st of July 2024, which is about 27 days back. Okay, so now on and from 1st of July 2024, we have what you call the new criminal laws. Okay, so this segment takes care of the history. Let's now, Samisha, you have questions or something so that we could.
Sir, I think my questions have lots to do with specifics, but can we start with the language of the overall new laws? See, I understand the language in the new laws is very vague. It uses words like annoyance, obstruction, disobeying orders. But if I were to, assess these words, these are matters of value judgment. They differ from person to person on their specific level of how they look at things. So, how will the interpretation of these laws take place as they are implemented?
Samisha, that's an excellent question. You see, what people also forget is that these laws which were enacted at that point of time, almost every word has received a judicial interpretation through the Supreme Courts and the High Courts. Right? So it's been, let's say, even if we were to rely on Privy Council, any student of criminal law knows the judgment of King Emperor versus Khwaja Nazir Ahmad. Right? That's a Privy Council judgment of 1946, which essentially talks about the rights of the police officers, how exactly it's a sovereign power coupled with a responsibility to investigate an offense, and how the judges or the judiciary cannot dictate a police officer how to investigate a case, because investigation is the supreme domain, right? So the word investigation was interpreted by the judiciary in that point of time. And from the year 1946 of Privy Council, we have been following it till 2024, right? There are certain expressions, if you change their word, the entire meaning changes, right? And if you have no opportunity to judicially interpret these words, then that becomes anybody's game. Because see, a bad interpretation of a vague word will lead you into jail. Because had it been any other provision, one would have understood, all right, it requires a judicial interpretation. But criminal law operates on certainty. We say, as students of law, when we read statutory interpretation, we are told that fiscal statutes and criminal statutes have to be literally interpreted. They are what they are. So if anybody causes you annoyance, you have to go to jail. Which also reminds me that in the year 2016, you had Shreya Singhal versus Union of India, right? That case originated out of one vague word in Section 66A of the then Information Technology Act. And then the Supreme Court said that whoever causes annoyance is a word that is so subjective that it would be left to a person to decide whether he is annoyed by that word or not, right? In fact, I may say something which may annoy, say, you, but may not annoy, I see Dr. Anand Kumar, so it may not annoy him, right? Does that mean that for the purposes of Samisha's subjective understanding of what annoys her, can I be sent to 7 years of jail? Right? And therefore, this term was held to be void for vagueness. Another point which I think is very interesting is the definition, or the newly drafted definition and BNS, which is what you call sedition. right?
Yeah, that was going to be my next question, actually.
Right, because if you look at section 197 of the BNS, right, it uses uh, a very interesting word which is called subversive, right? If you look at something subversive, that is something which has not been defined till date. Since it has not received any judicial uh, definition as yet, it becomes very, very difficult. In fact, section 152 is what I'm looking at, which is Act Endangering Sovereignty, Unity, and Integrity of India. This is one such provision which is going to cause a lot of trouble in days to come.
Is it just not अनेक शब्दों के लिए एक शब्द होता है ना, जैसे like पर्यायवाची शब्द हो गए, so it
That's right.
defines, it takes away sedition, but it talks about treason. But then what comes under the integrity and what comes under the ambit of 152, I think it becomes really unclear at this point. So how do we navigate these waters?
See, if you look at the rest of the provisions, it's okay. But if you, because what is sovereignty, integrity, what are those acts prejudicial, all of those have received interpretation from time to time. In fact,
Yeah.
there's a constitution bench of 5 judges which has already decided what exactly each one of those words are under the erstwhile sedition. But
Yeah.
you see, when the Supreme Court of India was dealing with this particular provision, and it directed the government of India to not register any cases, because it prima facie was of the opinion that this law has to go back, because this is
Yeah.
colonial, a part of our colonial heritage, so to say. Now, even when you bring out the new law, you still retain the provision, except you don't call it sedition. But every single ingredient of that erstwhile provision continues to remain in statute. Additionally, you also put very vague words so as to expand the net to bring in anybody that you want to bring into more. So let's say any disgruntled police officer can book any person under sedition. Because you see, I had a very interesting case. Suppose there is somebody who is objecting to the policies of the government, saying that, look, cutting off a forest in a particular area, that's a bad thing. You should not do. Right? There are many activists who are fighting, saying that, look, you can't cut a particular forest. And they start what you call a crowdfunding campaign for it. Right? Please donate for the purposes of raising your voice. We will print pamphlets. We will take our voice. We'll write to the governor. We'll write to XYZ. Now, any person, technically, if you have to bring it within the definition of sedition, even those activists who are doing are fighting for a right cause can now be booked in, and so would all of us, because we have financially supported that person, right? Even our 50 rupee Paytm contribution can land us in jail, right? So unless and until you have a specific judicial determination which recognizes that, look, any form of disappropriation of government's policy in the harshest of words will not tantamount to sedition, unless and until you are actually calling people to take up arms against the government. Now that, of course, is outrightly seditious, right? But anything short of that would be an affront to many things. It could be an affront to the freedom of association. It could be an affront to a freedom to form an assembly. It could be an affront to the freedom of speech and expression, because the wordings of the provision under section 197 uses the term whoever by word, spoken, written, visual representation. So tomorrow if somebody were to make a movie, right, and enact something, even that person will go to jail, right?
Absolutely, sir. So thank you so much for your answer. I think we can move on to discussing the comparison between the old laws and the new laws. But I have sort of
Right.
an umbrella question discussing, both of these points. Um, I really hope you start with answering, is the system ready for new laws? And I ask this because this will create a parallel justice system for decades owing to implementation issues. So, what are the changes? How do we navigate those changes with the confusion that is bound to arise?
All right. So for that, we have to enter into the real devil, which lies in the procedural courts, right? Because it is the procedure which decides what happens to a case. Substantive offenses, it's very simple. I'll just very quickly wrap up the substantive part and then come to this. Substantive offenses, you have the protection of Article 20, which says a person cannot be held liable or guilty under an offense or under an act which was not an offense on the date on its commission, right? So if an act which you have committed was not recognized as an offense on the date on which it was committed, then technically you cannot be held liable under it. That's the protection which is given under Article 20, subclause 1. In Latin, we call them ex post facto laws, right? Any student of criminal and constitutional law will get it. So for substantive law, the thumb rule is very simple. If you commit an offense before 1st of July, offense, right? Not the date of its registration. It's very critical to have that distinction in mind. If the offense is committed before the 1st of July, then what will apply to you is IPC, the Indian Penal Code, right? However, if the offense has been committed after 1st of July, then what applies is BNS, right? Bharatiya Nyaya Sanhita. Simple. The problem really is not that. The problem is in the metamorphosis between CRPC and BNSS. Now, before I take you to anything else, let's directly go to one very miserably drafted provision called Section 531 of BNSS. Right? Any law has what you call, any statute has what you call a repeals and savings clause. Okay? That repeals and savings clause tells the general public that X law has come to an end and Y law has to begin. Okay. At this point of time, there were doubts because many a times Parliament forgets to put that repeals and savings clause. Right. So then you are guided by something called the General Clauses Act of 1870. Now, the GC Act under Section 6 says that if there is nothing mentioned in a law as to when it will come to an end and when it will begin, then Section 6 lays down certain categories and parameters which decides whether the old law were to apply or whether the new law will. Okay? But basic thumb rules, because since it's a master class, let me, you would see me running from one law to the other, right? Because I must give you a holistic perspective. So the basic thumb rule is this. If there is any action undertaken under the new law, let's take the example of your BNS and CRPC and BNSS itself. If there is any action which is taken under the old law and which continues to go on and from 1st of July when the new law comes into picture, then you have to forget about the new act. It would be deemed to be an action which is actually undertaken under the new law, and therefore it will be decided as per the old law. Okay. If there is any new action which has to be taken, then that new action can only be taken under the new law, which is the BNSS. Okay. That ought to have been the general, the application of Section 6 of the GC Act, the General Clause. But Section 6 of the General Clauses Act only kicks in when the law does not have a repeals and savings clause. If the law has a repeals and savings clause, then Section 6 has no application. It is only the new law which will come into picture. And this is precisely why the drafting of the new law becomes very, very important. Okay. Without further ado, if we just go to Section 531 of the BNSS, it says 5 things. If immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry, or investigation pending. 5 things: appeal, application, trial, inquiry, or investigation pending. Then such appeal, application, trial, inquiry, or investigation shall be disposed of, continued, held, or made as accordance with the Code of Criminal Procedure. Okay. Appeal, application, investigation, trial, or inquiry, if it is pending. Right. Now, suppose there is an application for
grant of police custody, which is made by police officer before this new act comes into picture. Okay. Say that application was made on 10th of June, and that application was decided by the magistrate saying that I'm only giving police remand of 5 days. Okay. So from, 20th of June. So by 25th of June, that application was disposed of. Now, if the police makes a new application, right, after 1st of July, then the question will be whether those 5 days of police custody are to be counted in the new application, because under the new provision, police get 60 days or 90 days to keep somebody in police custody, right? So now whether those 5 days have to be adjusted with these 60 days or 90 days or not, that's really a problematic question. Because technically today the public prosecutor can argue whatever has happened in that act. Now the new act has come. Now he gets 60 more days or 90 more days. You see, it would mean, assuming that 60 days police custody or 90 days police custody is permissible, which I don't think it should be, but assuming for a second that you can send somebody in police custody for 60 days, these 5 days would in fact add on or would be set off. That's the confusion which would prevail, right? People are moving bail applications under the provisions, right? Those bail applications are now under new applications. Therefore, they have to be moved under the new laws. In fact, there are judgments and judgments which say that a trial is a continuation of an investigation. But what happens in a case where the investigation is completed, say within 90 days, the police filed charge sheet, but thereafter 1st July kicks in, and now the trial has to begin. Now, will the trial begin under the new BNSS or will it continue under the old CRPC? Now, why this becomes very critical is because there are so many safeguards which are there in CRPC, which today are not in BNSS, and vice versa also. Say, for example, let me give you an instance. And for those, I'm so sorry, I have to go back to basics. Under the Code of Criminal Procedure, even under the BNSS, there are 3 types in which cognizance can be taken. Cognizance can be taken on the basis of police report, which was erstwhile Section 2R, which is modern day particular provision in BNSS, which I'll allude to because it takes us time to even remember which provision is which provision, right? So that 172 CRPC provision, which was your final report, was the stage at which under Section 190 of the CRPC, a magistrate was called upon to take cognizance of an offense, right? The magistrate can take cognizance on the police report. It could take cognizance on a complaint, which was registered at that point of time under Section 200 of the CRPC, or it could suo motu take cognizance under 191 subclause C of CRPC. That was the law. Right? Now, at that point of time, the accused had no right of being heard. Under the new law, however, if the magistrate were to take cognizance, the magistrate cannot take cognizance in a complaint case unless and until the accused is heard. Right? So will that not create a disparity? Because under the old CRPC, when the magistrate was called upon to take cognizance, right, the magistrate was not required to issue notice to the accused. It was only after having heard the complainant and after having taken the pre-summoning evidence, the magistrate had 2 options, either to reject it or to issue process under Section 205 of the then CRPC if the magistrate found reasonable grounds of proceeding against the accused. Now that is absent under the new BNSS, because now the magistrate has no power to issue notice unless and until he has given opportunity of hearing to the accused. The question that I ask myself is this not prejudicial to the complainant? Similarly, let's take the converse. In a police case, which is of course registered on the basis of charge sheet, the magistrate used to take cognizance and the accused was only summoned thereafter. At least at that point of time, at the stage of cognizance, the accused has no right of hearing. That has been settled by so many Supreme Court decisions, which need not mention. In one swift move of changing this, you have changed the entire criminal jurisprudence. where in a complaint case, you will have to give opportunity to the accused, whereas for a police case, you don't have to give opportunity to the accused. So now you will have two sets of challenges. Equality before law and equal protection of law, Article 14. The accused, every such accused will challenge it on the ground that while you are hearing me in complaint case, you are not hearing me on a police case. So therefore, you are treating me differentially and there is no intelligible differentia. Therefore, Article 14 violation. In fact, every complainant will challenge this on the ground, saying that if you are not hearing him on a police case, why are you hearing the accused on a complaint case? Why is this step brotherly treatment to complaint cases? So very soon you are going to see a flood of litigation plaguing every high court, where a challenge would be mounted to cognizance orders in revisional jurisdiction, and the high courts will be confounded with this trouble as to whether, or let's say, of course, sessions case, then high courts. If it's a magisterial case, then of course the sessions court will be confounded with the trouble, whether it is this process which has to apply or that process which has to apply. Now, let me also give you another interesting angle of looking at it. We understand that procedural laws are retrospective. Procedural laws can be retrospective. And any law which is retrospective and which benefits the accused must be held to be read in favor of that accused. Right? So here is a case where the complainant might come and say that I am a very important stakeholder. I ought to have been, the accused ought not to have been heard, because otherwise it prejudices me. It infringes my vested rights which were created under the old regime. And therefore that challenge would also be mounted by them. So there, another thing that the courts will be confounded with is whether this particular provision should then be read retrospectively or prospectively. Right? So there's a lot of here and there. I'm just giving certain examples to show how exactly these provisions will create a lot of trouble going forward, right? Handcuffing, another very interesting example. Section 43 of the BNSS, which now empowers police officers for the very first time, mind you, to give powers to the police to handcuff people who are accused of a certain category of offenses. Now, imagine an under trial who is, let's say, accused of murder, right? And accused, innocent until proven guilty, not yet proved. He is an under trial. Until 1st of July, he was not paraded before the court in handcuff. But today, after the 1st of July, when the BNSS comes into picture, suddenly the police will put handcuff and parade him before the court. Will he not have the legs to stand and argue that this infringes his fundamental right? Because under the old regime, there was no such provision. But under the new regime, there is in fact a provision which empowers legitimately to the police officers to handcuff somebody. And what happens to those various judgments which the Supreme Court passed from 1980 to 1987, right? D.K. Basu, Pandit, Rudul Shah, Sunil Batra, where the Supreme Court has said that this is one of the most abhorrent practices. In fact, police manual ke provisions, I distinctly remember one case where Justice Krishna Iyer had struck down Punjab police rules which provided for handcuffing, said this is absolutely nonsense in a civilized society. You can't have people being paraded. Of course, there are exceptions. I'm not saying that, those people who have disrupted court proceedings, or those people who are accused of very heinous offenses like, terrorism, etc., must, the police must not take any protective or preventive actions. In those limited category of cases, it is understandable. But today, if you were to sort of put these people and make them march to the court and back, then that's going to be very troublesome, right? In fact, the new video conferencing system of having witnesses being produced, which is of course substituted from the erstwhile regime, which said that every person who is accused of an offense has to be physically produced before the court. What was the sense of that provision? The sense of that provision was, in police custody, we know of ways and means in which torture is inflicted. So the magistrate's job then was to look at the person, order his medical examination, and also find out whether the police is actually treating him properly or not. Right? That very vital safeguard today has been substituted with video conferencing. And we know that, Samisha, circling back to that question that you asked, whether we are ready to in fact implement this. Are we really? I have my doubts. Right? You have a section 105 of the BNSS, which now says that the police officers are investigated to, empowered to carry out investigation through audiovisual means. Brilliant initiative. But do they really have that modern means? You have heard of the Kerala DGP giving an interview saying, we don't even have computers, forget everything. These
Sir,
apps which have, yeah, sorry.
Thank you. So I'm really sorry to interrupt you. Thank you so much for actually, initiating that conversation. This was actually one of my questions with regards to the eSakshi app also. I remember this interview that was given by a 50-odd-year-old, police constable. And he's like, भैया मेरे को तो WhatsApp use नहीं करना आता है. How will I be able to upload the evidence that we are going to record, or the panchnama that will be held, or the search and seizure that we'll conduct? Because as far as I saw about the police training that were conducted in Chhattisgarh, those were 2-day, 3-day trainings. And this is a law that has been in making for so long. And this is a law that will take so long to actually effectively be implemented. So the machineries to be prepared, ready, and armed for it, I think the fundamental problem lies there, because there has been no proper training. There has been no proper mechanisms for actually preparing them for the war that is onslaught and onto upon us, is what I believe and see from this.
I agree. I mean, if you look at that particular provision under, section 173, subclause 3, if the information which is disclosed, I mean, it's your 154 FIR ka successor provision in the BNSS, right? So now they have included something very interesting. In fact, 173 subclause 1, let's just focus on this one provision and you will see how troublesome this is. Initially, under the laws, you had what you call 154(1), which used to say that if you were to give information which discloses commission of a cognizable offense, then what you have to do is register an FIR. Correct?
Orally and writing.
Right? Now that was entrusted to the police officer. Under 173 subclause 3, now if you are to register an FIR on a cognizable offense for which the maximum imprisonment term is 7 years or more, then you have to immediately dispatch what you call forensic experts for the purposes of conducting evidence gathering. The parliament realizes that they don't have forensic experts today. So they say that the state government shall notify a forensic expert to be appointed by way of a notification in the next 5 years. Does this mean that offenses will not take place in these 5 years? Or evidence gathering will not happen in these 5 years? Or that what is the police going to do for these 5 years? Evidence collect karna band kar denge? Or is somebody saying that for the next 5 years, India is never going to see any offenses being registered? Right? Will murder stop happening? Rape stop happening? Dacoities and robberies stop happening? Each one of these provision, mind you, entails a punishment beyond 7 years, or grievous hurt for that matter. किसी ने किसी से लड़ाई की, डंडा सिर पे मारा. Right? Now, if we have all of those things which are going on, the entire collection of evidence under section 105 read with this section 173 subclause 3 now becomes a problematic this thing, because since you have not collected, your eSakshi app is not functioning. You don't know, you haven't been trained to generate hash value. So your section 63 of the Bharatiya Saksha Adhiniyam certificate, which is successor to the erstwhile 65B certificate, is now rendered useless. I asked certain police officers when they had those questions. They said, "Sir, abhi to hum WhatsApp pe video bana ke magistrate ko bhej rahe." I said, "Seriously? Are you doing that?" Now, you understand it's going to be so easy for a defense counsel to get people out like this. Your murder weapons, your critical pieces of evidences collected, your seizure memos are all going to be rejected because they do not conform to section 173 subclause 3. Tomorrow I can argue this in court and say, since these evidences were not collected in the manner envisaged under section 173.3, read with section 63 for which your hash value is not generated because आपका network नहीं आ रहा है देहात थाने में, right? You are from Chhattisgarh, you know, let's say put any place in remote places like Dantewada, etc. How will you register an FIR? Right? Thirdly,
And sir,
there's another
this
big
sounds
problem.
so.
Sorry.
Yes, yes, please.
There's another big problem. Now we understand that under entry 2 to list 2 of the schedule 7, which is your state list,
Status.
the exclusive power to implement or to enact laws for the purposes of state has been conferred on the state government for the purpose of investigation, police, etc. etc. So you have never seen National Police of India. You have the MP police, or you have the Chhattisgarh police, or the Delhi police, or the Maharashtra police, right? The only exception, by the way, is one state, which is West Bengal, which has a West Bengal police as well as Calcutta police, because that one city has a separate police act. Apart from that, nowhere in the country would you find any other supra state police. Now, if you look at 173 subclause 1 in that light, you would see information which is given in respect of a cognizable offense anywhere in the territory can be registered. Now, anywhere in the territory, suppose an offense has taken place in Gujarat, will the MP police decide to investigate? If MP police tries to investigate a Gujarat mein committed offense, that's a breach of federalism right there. Right? And we all know that federalism is held to be part of the basic structure. This particular provision tomorrow can be challenged on the ground that it violates the basic structure. By the way, I'm not against EFIRs or zero FIRs for a second. I think it's a laudable initiative. But what ought to have been mentioned here is that anywhere within the territory of the state, so at least the state government has jurisdiction, and they would have clarified, they could have added a proviso that even if it is committed beyond the territories of the state, it is that particular state which will register, and that the police will transmit to that particular state for the purpose of its registration. That has not been done in the law. So today, I could prosecute somebody in Kerala as a police officer sitting in Uttar Pradesh. You realize it's so disastrous at various levels that it will violate even those erstwhile provisions. You remember there was a specific chapter in CRPC which deals with inquiries, investigations, and trials, right? It starts with what you call a specific provision, is the 176, 177, 178, 179. It says, ordinarily shall be inquired into or tried where the offense has been committed within the local limits. The various, that expression is very important, within the local limits of its jurisdiction. Now, today, if you register an FIR outside the local limits, but the BNSS still has those provisions, is there not a conflict? These are mutually destructive provisions. For the purpose of registration of FIR, I give you the entire jurisdiction all over the territory of India. But for the purposes of investigation, only the state police will do it. Then the Gujarat police will have to take consent of Madhya Pradesh police to allow it, to permit it to investigate. But why will Madhya Pradesh police ask Gujarat police to enter into their state? Is the Madhya Pradesh police not competent? Then the question would be, who investigates on an FIR which is registered outside the territory of the state? And this is going to give rise to such practical problems very soon that either one of these provisions will have to be struck down. And you see, Samiksha, the problem is these are at very entry level. Right? The provisions of, let's say, preliminary inquiry, you have completely done away with, Lalita Kumari.
I was just going to ask you this question. I mean, this is such a double-edged sword, and it's so juxtaposed to say that this is such a victim-centric approach that the law has taken. But at the same time, it, according to me, defies the principles of natural justice and, proving guilty beyond a reasonable doubt, because we don't need the principles of Lalita Kumari anymore. You don't even need to do. So earlier, Lalita Kumari said, which was, of course, the need of the hour back in 2014, 10 years back,
Yeah.
that you have to register an FIR, because the more number of registrations, the more number of incidents that can see some light of the day. But now the powers of the police have been expanded so much that they have the absolute power to conduct preliminary inquiry and not even enquiry before registering the FIR. So does it not reduce the efficiency of the cases, specifically those cases which have already been lodged and are in trial? So how do we resonate this with Lalita Kumari case, according to you?
See, in Lalita Kumari, there was a specific, unequivocal pronouncement on the principle that if the information relates to commission of a cognizable offense, the police officer cannot say, but why? He has to or she has to register the offense, period. Right? It is only in a very limited category of cases that preliminary inquiry was permissible. Not too many people know in Lalita Kumari. Let's say it's a family dispute, or if it's a by and large,
Property.
civil commercial dispute, right? Very, very specific, exceptions to the rule. The general rule continued to be no preliminary inquiry. Why was it? Samiksha, the reason why it was because it was to do away with what you call the institutionalization of corruption and political clout in police stations. कॉल आता था पुलिस ऑफिसर के सामने, ये केस रजिस्टर नहीं करो, इसको छोटी धाराओं में लगाओ. Why? Because let's say a criminal breach of trust committed by a merchant or a banker, section 409 of IPC was converted into a 405. Why? Because 405 में 3 साल, or if it's by a merchant and agent, then it could be minimum 10 years to life imprisonment. Right? So the police usually used to take money or used to get a phone call, and thereafter they never used to register FIR. To do away with this very bad practice, which was extremely pernicious, the Supreme Court then decided to pass the law that it passed, right? Saying that we are decisively putting an end to this corrupt practice. The police officer is obligated to first conduct, register an FIR, and thereafter conduct the investigation. Under the new law now, it has reinforced that practice which was done away with and has taken India back to pre-2014 days. Now a police officer has to first conduct a preliminary inquiry to ascertain. Now it hits both the complainant as well as the accused. But now let's look at what is that range of that preliminary inquiry. For any offenses ranging between 3 years to 7 years, preliminary inquiry is the discretion of the person who is to register that FIR. I may say that I don't wish to register, or I may even call the accused without having to serve him a 41A notice, which I otherwise had to do because of Arnish Kumar, right? If it was an offense under 7 years of age, punishable with 7 years imprisonment, then the police officer was supposed to serve a 41A notice. Today, in the guise of that preliminary inquiry, I can call the complainant, I can call the accused, and I can say, chalo, ab kaun zyada paisa de raha hai? Us hisab se I will decide whether I want to register an FIR or not. You have essentially institutionalized corruption. And I'm not saying this out of thin air. The Supreme Court has given this as a principle of law, that we are doing this because we want to curb instances of political clouds and corruption in the police system. Today, you have given more power. And why is it troublesome? Because 97 offenses have imprisonment ranging from 3 years to 7 years. Theft, cheating, criminal breach of trust, grievous hurt, acid attack, right? Stalking, voyeurism, all those offenses, today the police will first sit and say, Madam, case nahi banta aapka. What is the police officer really asking? Right? So that institutionalization of corruption has been done through this vice of preliminary inquiry, which to my mind was not justified. It ought not to have been there. So I don't think we are going any progressive. We are going way back. There are
So,
so many. Sorry.
also, will these new laws with regards bail make it more difficult to attain a bail regarding the changes in the custody powers and the powers of the police that have been expanded so widely and drastically, if I may say so?
That's right. That's right. So now, earlier, if you had those, section 167 was your provision, which used to say that uh, custody not exceeding 60 days or 90 days in case of a cognizable offense punishable with whatever time period was indicated, right? Today, we all knew that the maximum amount of police custody was only 15 days that the magistrate could allow. Today, with the new law which has come into picture, the police can seek custody beyond that period of uh, 15 days, right? Now, under this particular provision, which is section 187 subclause 3, right? There was, I will first tell you what the previous law was and now what the new law is. Under section 167 subclause 2, there was a specific proviso which says, but not including 60 days, but not including police custody, which meant that 15 days was the maximum period for which the police can have your custody. That very expression, but not including police custody, has been done away with under section 187 subclause 3 of the BNSS. Under the BNSS, police can seek custody till kingdom come, which is 60 days or 90 days, and is not required to be limited to a period of 15 days, right? Now, of course, there was one line of judgment in Anupam Kulkarni, because in my previous interviews where I said there was some criticism by some folks saying that, Anupam Kulkarni was overruled, because Anupam Kulkarni said 15 days and not more. There was a later case of Senthil where it says that 15-day period could be any period within those 15 days. But even Senthil recognizes that maximum period is 15 days. You can't exceed 15 days. That's the critical point. 15 days police custody means 15 days police custody. Today, if you have, and what you have done is, here the mischief is by omission, as I already said. The omission is that particular proviso which said 60 days, but not including those 15 days of police custody. So today, it essentially arms the police officers to seek custody way beyond 15 days. And as I gave you that example, with the coming in of the new law, even those people whose custody was only given for, let's say, 3 days or 4 days, there's an unwritten rules. I was having that discussion with the magistrates sometime back. They used to tell me, sir, what we usually do is criminal breach of trust, cheating, white collar crimes, 3 days, 4 days custody is sufficient for police. But for the purposes of, let's say, murder or rape or sexual assault, there we give a longish period of custody because interrogation is required. But now let's look at it, Samisha. Today, as a police officer, if I have to keep somebody in custody, we know what reasons I can cook up. I can say that I want this person to be confronted with a witness who lives in Kerala. The offense is committed in Delhi. So I have to take this person to confront with that particular witness. For that, I need 10 more days police custody. After 15 days, can the police not ask it? Yes. And why is it problematic? To answer your question on bail, why is it problematic for bail? Is because the easiest way to counter an argument for the grant of bail is I require his police custody. His custodial interrogation is necessary. And to extend that period of custodial interrogation, I can give a number of reasons under the sun. Right? So it has effectively conferred more discretionary power at the hands of the police officer to register a case, to conduct a preliminary inquiry, right? To register it anywhere in the country, but to investigate it locally, right? To seek police custody, to carry out handcuffing, to do whatever it deems fit in its own wisdom. And the most pernicious of provisions is section 107 of BNSS, which defines what you call proceeds of crime. Right? In fact, but before I come to the proceeds of crime, there's one very important thing, which because I think I must also draw a comparative analysis with other provisions when it comes to police custody. It is not that other laws do not have higher number of days for police custody, right? Say, for instance, NDPS Act says that the police may file a charge sheet within a period not exceeding 180 days, right? But even there, the initial 15 days still retain. Right? Or let's take UAPA. There, the police custody can be taken from 15 days till a period of 30 days. However, even under terrorism offenses like UAPA, the police officer who has made the arrest has to give his personal affidavit to satisfy the magistrate as to why further police custody is required, as against orally making that statement. So there is a certain semblance of accountability attached so that the police officer can be rounded up. देखो तुम झूठ बोल रहे हो. There you said you needed police custody, but you just wanted to keep that person in custody for the heck of keeping that person in custody, right? But here, those very provisions have been engrafted under the new BNSS without the procedural safeguards which were there even in those legislations, right? That's the problem. Now coming back to the section 107 argument, right, point, which is your proceeds of crime. PMLA under section 3 and 5 had what you call attachment provisions. Attachment has to be carried out within a period of, after a period, the power to attach first is conferred only on the director or the deputy. Thereafter, the power of attachment has to be judicially defended, because defended before a judicial forum, namely the tribunal which has been constituted and the appellate tribunal, and there's a high court which is there, right? And while attaching somebody's property as proceeds of crime, you have to have material on the basis of which you come to the satisfaction that X property has been made due to ill-gotten wealth, right? Which is the tainted money has been converted into white, which is the office of money laundering, right? Or you're projecting a tainted money or the assets which are made out of that tainted money as untainted money or a white property, right? That element of proceeds of crime has to be decided and established, and therefore that provisional attachment comes to an end after a period of 180 days. Under the new law, which is the BNSS, that provisional attachment power has been now conferred on police officers. They can carry out, and that is not subjected to the scrutiny which even stricter laws have, right? You had an appellate mechanism, you had a complete checks and balances system, which is completely absent under the BNSS. So that is something which is again very problematic. Lastly, on the evidence part, I think I should also, because we have talked the least about the Bharatiya Sakshya Adhiniyam. Luckily, this is the one provision which has been least tempered, right? But what has happened with Bharatiya Sakshya Adhiniyam is that the definition of what is primary evidence and what is secondary evidence has been changed, right? Now, under section 57 of the Bharatiya Sakshya Adhiniyam, a primary evidence also includes digital copies of a computer generated output. Very, very problematic, right? Because erstwhile, just to give you an example, why is it important? I think your screens are frozen, or maybe am I audible and visible, guys?
Yes, you're audible and visible.
Yes, sir. Yes, sir.
All right.
Maybe
So
some
under-
lag, yeah.
Yeah. So until the last time, under the previous regime, what used to happen was that there was a computer and there was a computer generated output, right? There's a computer, and let's say that computer has generated a paper output in the form of, let's say, a print of a particular document that you have, right? That computer output could not be called a primary evidence unless and until you had what you call supported by a 65B certificate, right? It is, and back in the days, you don't have to produce the laptop or the computer every point of time. Earlier, ho raha tha ye, until the Information Technology Act as well as correspondingly Evidence Act were amended to bring in what you call the 65B, which recognizes that you don't have to produce the original device so long as you can submit a certificate, which will have the following things under 65B subclause 4. It should identify the device. It must give the unique identification number of the device. It must say at what stage was it collected, what is the date, time, file size, file type, storage capacity, what was the date of its creation, what was the date on which it was last accessed, what was the date on which it was modified. And only when you have all these details will you not be required to produce the original. Only that certificate will do, and it will be deemed that this particular output is the original copy of generated from that device, and therefore it would be primary evidence. Everybody understood? That was the law under the old time. Under the new law, what they have done is they have changed the very meaning, very definition of primary evidence, because now they say that even copies generated from original device shall be deemed to be primary evidence. Suppose there is a WhatsApp message. I see 5 people, so I'm going to very quickly name you guys. Okay. There's a WhatsApp message which originates, let's say, from Nehal. It goes to Ananya. Ananya then changes that WhatsApp message, goes to Sanjukta. Sanjukta changes it, sends it to Siraj. Siraj changes it and sends it to Monica. Okay. And Monica files as investigating officer. Monica files it before Samiksha, who is the judge in the matter. Okay. Now, under the old law, what was there with Nehal is the only primary evidence, provided Nehal can send you what you call a certificate under 65B. Under the new law, however, Nehal's message to Ananya, Ananya's message to Sanjukta, to Siraj, and thereafter Monica, everything will be treated to be primary evidence. Now imagine if your WhatsApp message is being treated as a primary evidence, which is not the original on your screen, but a copy which is circulated. Imagine what potentially disastrous situation is going to result in. You see, a secondary evidence is only to be shown when the primary evidence is not available. You have to take leave of the court. You have to, request the court to consider this. Otherwise, your evidence will not be admissible. Suppose you are relying on a sale deed, and you lose that sale deed. Then you have to apply to the court, seek leave, and then say, I also have a photocopy. Please look at it. And if somebody were to produce the original sale deed, then they will not consider your photo. Today, under the new law, any copy written by a Sanjukta or a Siraj or a Monica will have the same status as if it was generated by Nehal. We are assuming that Sanjukta and Siraj are incapable of tweaking the file or changing it. Right? You realize how difficult, how you have changed the very meaning of primary evidence when it comes to digital documents or digital evidences, and the consequences that it would entail. Suppose somebody writes a suicide note saying, I so and so have been wronged by X, and therefore I've been driven to the point of committing suicide. So therefore X is responsible for my death and nobody else. That message, Nehal comes and takes a screenshot of that message. I'm the deceased. My phone is lying here. She opens my phone, takes a screenshot of that message as an investigating officer. After 90 days, Nehal is transferred. Ananya takes over the investigation. Now, Sanjukta has taken over the investigation from Ananya, right? Thereafter, Siraj takes over the investigation after another 60-70 days. Thereafter, Monica takes over. Now, somebody comes to Monica and says, Madam, please remove my name. No, I'm X. Why don't you put Y there? Monica puts a Y. Nobody is calling Nehal to say whether this particular evidence which was taken was in fact proper or not. But today, Monica's screenshot which she submits before the court becomes primary evidence. And now instead of X, Y is in jail. The second requirement, of course, is chain of custody has to be proven under the next explanation. Now, what is that chain of custody? Chain of custody is that whatever is the file which is being generated is the same or not. How do you decide? How do you find? Unless and until, because if I were a defense counsel, I would have said, I want to examine Nehal, I want to examine Ananya, I want to examine Sanjukta. All the 5 IOs have to be examined. Can I do so now under the new law when what I have is only Monica's screenshot and not what was the original screenshot versus what were the different copies generated at various points of time? Right? So you see, the problem is that you have turned the elementary principles of Evidence Act on their head. Which is why in a couple of interviews I've said this is going to be a prosecutorial nightmare and a defense counsel's Disneyland. Right? They're going to have a field day. Right, Samisha? So now I think that by and large covers most of those provisions that we were dealing. Is there something I'm missing out on? Please do.
No, sir. But I have two questions that I think we can end our discussion with, and before we take questions from everybody else. There was this interview where senior advocate Rebecca John, she quoted and said, these new laws are like old wine in new bottle. So how do you interpret that statement? That's one. And my second question to you would be, I think the judgment that you were discussing about Veera Shri Krishna is the Muhammad Ghiyasuddin judgment, if I'm not mistaken.
That's right.
So it spoke about every saint having a past and every sinner having a future. So the aspects of restorative and reformative justice system that we have here in India. So how far do you think it's a relevant practice that we are going to see in these coming laws? Because it does talk about, punishments such as, non-punishments such as rehabilitation and community service, taking away the aspect of, imprisonment. So what I'm trying to understand here is what is the approach that this law aims to take? Is this a victim-centric approach? Is this an accused-centric approach? Is this a police-centric approach? So please guide me here, sir.
So let's first deal with this second question because it's very interesting.
Sure,
First,
sir.
also, let's trace the origins of this particular provision. Section 4F under the BNS now defines community service as a form of punishment. Right. The first question is, what is this community service? Because ideally, one would say that, yes, it is victim-centric. It, now empowers people. It's on the reformative idea of justice, which has been propounded by a Maliamet Committee report, right? Thereafter, the 2005 Criminal Law Amendment Act, etc., etc. Various law commissions have also suggested. This new inclusion, of course, was also the claim to fame, saying, you see, we are abandoning punitive measures and we are walking into the sunrise of a reformative India and so on and so forth, right? But let's examine it slightly. Let's do the post-mortem of this provision. When you say community service, what do you mean? It has to be defined, right? Because it's a form of punishment which has been imposed, right? There used to be, if you remember, Samisha, there used to be something called admonishment, right? In my career, I saw one admonishment. Where the judge called that person and said, I severely reprimand you, dobara mat karna. Go now, you're free to go. That was admonishment. Right? Now, that has, of course, been now substituted with community service, which has now found a novel inclusion, as has been said. Do you know that in the year 1974, this was already suggested by the Criminal Law Reforms Committee? The Criminal Law Reforms Committee at that point of time, the Law Commission of India, of course, suggested this as a measure. It defined what was community service. It also said how many hours of community service were supposed to be carried out. The reason why it was rejected was because it said, let's keep 70 hours of community service. And suddenly, the Labor Commissioner objected to it, or the Labor Ministry, objected to it, saying, you can't have community service exceeding 50 hours because under the Factories Act, that is the minimum hours which have to be put in by a skilled labor. Agar aap usse zyada kar rahe ho, then that will somehow offend the provisions of the Factories Act. That's why the legislator said, chalo isko late hi nahi hai, let's not include this, right? Today's Parliament has brought out the new law. I won't say government, I'll say parliament has brought out this new law, right? But it doesn't define what is community service. It doesn't say that X form of service will tantamount to community service. So when you don't define what is community service, then serving at a religious place could also be community service. Planting trees could also be community service. Sitting and asking somebody to do their homework can also be community service. Right? And why
In
it
the
is
light of the recent case, writing an essay also could be
writing
community
an essay
service.
could also be community service. You are serving the community by writing
Yes.
something about the community, right?
Yeah,
So,
absolutely.
so now, but it's very problematic because criminal law again has to be certain. You are giving somebody a punishment, let's say defamation, which can in today's day and age lose somebody's constituency, right? Can disqualify somebody from contesting an election. Today now has been given an punishment is now community service for that offense of defamation, right? So at one point of time it is so severe, but now you have sort of removed, or let's say drunk behavior in public, that is now punishable with community service. That's the new one.
Yeah.
Right? Or let's say if you don't, you had an erstwhile, I'm forgetting because we used to do a lot of matters during COVID, which said that if you are, say, not complying with Section 144 CRPC, failure to act according to the instructions of the government or an officer will entail a punishment. Even for that, they have put a community service. So if I were to say not respect curfew, then I will have to sit and write essay somewhere.
If you were not respecting the curfew, if you were in the community, then you have to do the community service. So I think that's very ironical by the nature of it.
Now,
No, but sir, what I also mean to say is if they have included, I'm really sorry, but if they've included provisions like community service and rehabilitation, the least I think I was seeing to also expect in these new laws were, laws made specifically for open jail systems, which is again a very, precedent-based procedure that we have in India right now. And jails, of course, I think they can take the garb of jails being a state subject and states having an authority and control over those. But I was really hoping to see some binding laws for open jail systems. If you're talking 20 years from now, 30 years from now, and we're talking about a restorative, reformative criminal justice system here in India.
You're right, Samisha. I think what they are trying to do right now is only to introduce this on an experimental basis and see pilot basis and see ye kaisa chalta hai. Say Juvenile Justice
Wow.
Care and Protection Act has a section 15 which specifically talks about community service, but all the state governments have laid down laws. They have their own policies, state specific policies which define what is community service, how many hours you are supposed to put in, what exactly are the kinds of community service. Even within community service, there are various kinds, right? Let's say even in jail manuals, you have, let's say somebody is given a rigorous imprisonment versus a simple imprisonment. What are the duties of a convicted fellow who is charged with a simple imprisonment has to do very different kinds of labor vis-a-vis a person who has been given rigorous imprisonment. I have seen it in my own eyes in Tihar. I just asked the jailer there and he showed me that these people who are actually laying down roads, etc., are the ones who have been given RI instead of an SI or a simple imprisonment. The ones who are, say, helping in kitchen, etc., are all simple imprisonment, but toilet duties are only given to rigorous imprisonment people. So you see, even there, they have a distinction, a well carved out distinction. Everything is mentioned in the police manuals or the jail manuals or say JJ Act ke under bani hui policies. But here in CRPC you have nothing. You have not even taken the pains. I mean, by you, I mean the dear, good-witted, good, well-meaning legislators have
Lawmaking
not,
authorities.
have not taken the care to write even something as simple as this. Community service as may be notified by the state government. A
That's
simple
very
tweak,
silent. Yeah.
a simple tweak could have, saved this provision. So I understand. I'm not, criticizing for the heck of it. But what I'm going back to is that if you leave a provision vague in criminal law, then that has a deleterious effect on the life liberty of an individual. Today, an accused has no right. You are at the mercy of the jail authorities or the judge. He will decide what is a community service for you. It could be road laying, it could be cutting portions in some, hilly region. It could be fetching water. It could be anything. You see, so that's a problem. Now coming to your first question, which Miss Rebecca John had mentioned, it's an old wine in a new bottle. Yes, the chapterization is the same. 95% of the provisions are same, but the inclusions, which are less than 10 in number, are so sinister that they completely thwart any semblance of an idea. And merely changing names is not going to do the trick. I just wrote a post sometime back where I discussed about Prakash Singh PIL, which has been pending in Supreme Court since a long time. In Prakash Singh, the Supreme Court looked at the manner in which the police reforms have to be undertaken. Please give them better salaries. Please not keep them understaffed. Please give them better infrastructure. I have visited personally to Dehat Thanas where they can't tell you the difference between mouse and a chua because their understanding of a mouse in a computer system is akin to a chua. They have never registered anything. And you expect those guys to download an app and generate hash values. Hash values. I mean, do you really there are many senior police officers who have told me that the entire training has been useless for the simple reason that even your standard operating procedure, the SOP, was released only 5 days after the laws came into picture. So, आप क्या सिखा रहे हो? What are you teaching them? What are you training them? Poor police officers today are left in a lurch to hold their WhatsApp cameras, record evidences, and send to the Elaka magistrate. So today it's not a secure platform, right? You are just sending something to somebody. Tomorrow the Elaka magistrate changes, a new Elaka magistrate is there. And I want to question the seizure that you have made under section 105 now. You can't establish your chain of custody. You can't say whether it was sent on X date, Y time, because now the phone has changed. But you are only relying on a copy of that particular seizure process. You haven't generated a proper hash value. And the worst part, section 63 now has a part 2, which says it has to be filled by an expert. The standard operating procedure at page 32, if I'm not mistaken, says that that expert is nobody but the station house officer of the police station. Welcome to the new age of experts where they are counter-signing. So somebody seizes, say an IO is an SI seizes it, but the SHO who's a 3-star now becomes the expert and puts a seal of approval. It's going to be fun cross-examining both of them. You see, but apart from the lighter vein, please look at the disaster. Suppose a murder weapon was seized. You have created an entire SOP around it. You say that you have to have a 3.2 megapixel camera or upwards. Certain standardized cameras have been indicated, right? Then you have to approach the scene of incident after opening the camera. You have to then start recording. Let's say if you are recording, let's say a weapon or an injury, then your camera angle has to be perpendicular to the injury. At 90 degrees, you must take that video and then you must go there and then the entire filing procedure, etc. has to be scanned. Somebody told me, sir, in a seizure which goes on during a raid or whatever, where the seizure process itself takes 6 hours, how can we have the bandwidth to upload 3 GB of data? That's a very important question because now it says you can't break a video. If you can't break a video, then you most certainly, I don't feel that unless and until you are operating on a 5G network on a cloud system which is enabled, that you can immediately transfer that data at such speed. And by the way, 105 says transmission has to be forthwith. So today, if the police officer sends that because sub data upload nahi ho raha tha, it takes them 3 days to upload that data on their very bad network, because you are now talking about some rural region in, say, North Karnataka. It doesn't reach the magistrate on time. Does that mean that the evidence collection itself is flawed? Of course it is, because you have been unable to explain proper chain of custody. Therefore, I will attack it on two grounds. I will attack it on the ground that it no longer is a primary evidence under Section 57. Secondly, it is not in consonance with Section 105 because it was not forthwith transmitted. And therefore, your murder weapon, which is a most crucial piece of evidence, must be discarded. It is inadmissible. Without a murder weapon, which is lying right there, congratulations on getting my client convicted. Right? So you see, it is the entire effect is going to be very, very bad, to put it mildly. All right, I think we can take a few questions. I'm so sorry. It's just
Yes, no, not a problem. I think it was a song to yours listening to you. I think, sir, I'll club the questions which are similar sounding or have,
right.
generally same topic. So Rebecca asked, in view of the modern society, completely revamping the criminal laws in India, shouldn't it include sexual offences, and they should have been made more gender neutral? To add to that, I think we can also talk about Section 377 being completely taken off, and there is a no parallel law talking about that. So how do you address that, sir?
Yeah, well, so the factum of general gender neutrality was also before Justice Verma Committee. So when they came out with their report in the year 2013, they did emphasize on it that ideally we would want the provisions to be gender neutral. Now, if you look at POXO Act, right, for a minor, the provisions are gender neutral, right? So if there's a minor, irrespective of whether it's a boy, girl, or a third gender, and I'm clubbing everything within the definition of third gender, so please don't take me otherwise. It's only for the paucity of time, right? It would always be an offense against that particular, it would be an offense nonetheless, irrespective of the gender of the person. It is something, Samisha, which I think is, futuristic. Today, we have judgments like Priya Gupta versus State of MP, where a woman who was holding another woman while she was being raped was held to be not an abettor and therefore cannot be convicted for rape under 375, 376, right? We have so many of those instances. In fact, even the Delhi High Court on marital rape has given its finding and has sort of referred the matter to a larger bench. So this is perhaps a discussion. Should we have gender neutral provisions? Of course. Is it the right time? I don't know. I can't say, because we need a lot of empirical data to back this claim, because it is a very fiercely debatable point. And this will, I mean, I have my personal views, but it doesn't have to be here for everybody to hear, because that would require a different discourse altogether. Now, coming to the second point, which was the question that you raised, is Section 377 omission. Today, for any form of just to borrow the expression, not my expression, unnatural offense, as they call it, right? Or let's just call it what it is. Any incident of, let's say, non-consensual sexual activity between people of the same gender, you will have no equitable provision to go to. So today, as if it were, Section 377 continued to exist in the statute book for all cases of non-consensual sexual encounters, right? And to that, the judgment by the Supreme Court had exclusively carved out that exception. But today, if there is, let's say, a person from the gays, bisexuals, lesbian community who has been sexually assaulted by a member of his or her own community, then that person has no legal recourse to. In fact, it is going to be so disastrous that any person who is booked and who is an under trial under Section 377 can today come up and say, look, it has been done away with. The parliament in its legislative wisdom has omitted this very provision, which means they don't view it. So today, as somebody who may have assaulted, that person may also get out by saying that today the new law does not have any penalty for it, which means that it ceases to be an offense. Then why am I being prosecuted because I committed an offense before 1st July? And the courts will have to consider this seriously. because this has happened with various provisions in the past which were offenses but later on were not offenses. Let's say adultery, Joseph Shine, many people who are being prosecuted under that particular provision are now getting out on bail and are also being acquitted because adultery no longer is a crime. So those people can come up and say that, look, it's no longer criminal, so why investigate? But I'm looking at another very different type of offense, Amisha. When I'm talking at instances and incidents, very depraved, but bestiality, right? Let's say there have been instances and incidents involving animals which have been the subject matter of sexual assault. Now, the only way that you can go is Prevention of Cruelty to Animals Act. But those provisions are not as, you see, with as stringent punishment terms as that 377 was. Today, a person would have thought twice or thrice before conducting any sexual assault on an animal, because they knew that it was carrying an imprisonment of 7 years. Now what? So that, again, mischief by omission. Right, Samisha, please. Any other question?
Okay, I think so. We can take one more question. That's a very progressive, onlooking question. Amit asks, we discussed about lots of challenges and implications under the new criminal laws. However, are there any remedies that we can expect in the near future by the lawmakers and the authorities?
Yes, there are. You would see that there are certain governments which have formed committees to review those laws, right? Many committees have been formed to check whether these laws are actually workable or not. And the state governments, of course, investigation, etc., all the matters within the concurrent list. Some of those matters are within the state list. Therefore, the state governments have all the power to amend or to suggest whether these laws will come into force or not, or to what extent will they be retained in the statute book. So it's going to be a complete, I'm visualizing a situation where in one state you have the IPC only or CRPC, and in another state you have BNS, BNS. We are going to go back to the 18th century where kingdoms had different laws and there was so much trouble that I just mentioned. Which law is to apply? Right? So it's, see, for criminal lawyers, criminal practitioners, it's going to be a jolly good ride. Right? So when I'm in fact holding these sessions, I am talking something which is against somebody's greedy professional interests. But I think there's a larger call that we are answerable to tell you exactly what these laws are and what implications do they have on the lives of people, because these three criminal laws are going to affect us, all of us in this country, right? They're going to affect every Nagarik and their suraksha.
I think so. We have passed the time. I think I all of us really regret having paucity of time, and I really wish we could have some more time and more number of sessions to actually cover. And I think this was a grievance we were discussing in the morning as well. 1.5 hour session doesn't justify the overhauling of three new laws altogether. But thank you so much. Thank you so much for dedicating a time out on a Sunday for us, sparing some time out for sharing your insights. And I really wish to have you soon over again for yet another discussion and for yet another, personal, very, very strong holding opinions on topics that really need discussions about. Thank you so much, sir.
Thank you so much, Samisha. Thank you so much to Lawctopus, and most importantly to all of you who have been so patiently listening to me. This is very heartening. Thank you so much.
Thank you, sir. Thank you. For the panelists, for the STP learners, you all also can leave the session. I will be sending you out the certificate details on the groups only. For other attendees, I request you all to please stay back. Thank you, sir.
I'm not one of your certificate attendees, right? So I could just.
If you wish to have one, we can make a special one for you, sir. Definitely, sir. All right. Requesting all the panelists to leave, please. I'll be sending you out details shortly. For other attendees, I request you all to please stay back. I have a bonus registration opportunity that I want to discuss with you, which I'm really excited about. So you can also leave, sir. Not
Okay,
an issue.
thank you. Yeah, that was.
Thank you so much, sir. All right. Hi, guys. Good evening. Meenakshi, Madhura, I'm still waiting for both of you to leave. Okay, hi guys, good evening. Thank you for staying put with me till the end of this session. I'll take all your questions slowly and steadily. I'm opening the chat box once again. In case you do want to send me messages there, I'll be taking them up right now. But before that, let me first start things in a rather chronological manner. Okay, I'm sending you the link for the WhatsApp group that we have made for this webinar specifically, which will talk about all the important details, all the important information, also with regards certificate as well. So I'm just sending you the link. You can click on this link to join the group. All right, I have sent the link on the group. So that's one. Let's get the other thing out of the way. There were so many questions to me asking about the certificate. So of course, certificate is optional in nature. You can avail your certificate by clicking on this link and entering this code. Okay. Sure, Moksh. I'm also sending you out a couple of forms. I really request you all to stay back. So this is the certificate generation link. You can click on this link and enter this certificate generation code. And by paying 100 rupees, you can avail a certificate for this webinar. Now, one very important thing, we will issue you a certificate within a week. So once you enter your details, we will be sending you out within 7 days of you sending the notice out. All right. Other important requests that I have from all of you is to fill this EOI form. Now, what is an EOI form? It's an expression of interest form. So Lawctopus Law School, I'm sure you guys are aware, thrives on the input that we receive from you all. We thrive from the support and the opinions of you all. So I really request you all to please take 2 minutes of your time to fill this expression of interest form, because we want to assess what is more that you want to see from us, what are the topics that you would like to conduct sessions, courses, workshops on, and we'll be very happy to do that for you. So please open this link and please fill this expression of interest form. Now, I want to also talk to you about what you're here for, the bonus registration opportunity. So I'm going to be sharing my screen in a bit. I'm also sharing the link of the criminal drafting course that we have on offer today. So you can read the details of this course by clicking on the link I'm sending you on the chat box. I'll be sharing my screen and talking about it as well. But if you want to read alongside me talking, you can definitely go ahead. Now, I hope my screen is visible to you all. Can I get a prompt from any of you guys? Just like a thumbs up or so? Okay, thank you guys for giving me the prompt. Now, why these courses? So our mission at Lawctopus Law School is to inform and inspire careers, because there's so much scattered information out there, but so less information that's actually substantial, chronological, and accumulative in nature. So we want you to not be restricted to theory. We want to be the bridging gap between the theory and what actually happens in real life. Because these are the crucial aspects that you need to know, and the crucial, skills that you need to build as you progress and make a career in these fields. Along with these courses, we keep having supplementary masterclasses and webinars such as this one. We very frequently keep having them. Now, what are the benefits of doing the course at Lawctopus? It helps you become a better thinker, a better practitioner, and We teach you concepts that are not taught in law schools. So whether you are a first year law student or a practitioner with experience or somebody who's looking to change or divert their trajectory, I think Lawctopus Law School is the place to be. We have lots of practical assignments alongside every course. For example, in the criminal drafting course that I teach, we give practical assignments such as drafting of a quashing application, drafting of a bail application, drafting of a maintenance and a DV application. So that's the practical angle that we bring to things. And we also introduce you to career possibilities and different avenues that you can undertake. We also give you an internship opportunity with firms depending upon your performance. And we also give you an opportunity to publish yourself with Lawctopus's Journal Academy. All right. Just give me 1 second, guys. All right. Apart from that, we keep having lots of career-related webinars as well. Just give me 1 second, guys. All right. Now our mode of learning is completely online in nature. We are completely, technology based. So our reading resources, self-assessment modules, live video lectures that are conducted every week, discussion portals, along with compulsory assignments and feedback is something that we do very actively. We keep having masterclasses by legal luminaries as well as having webinars about career-related sessions and practice-related sessions. So, as I said, it's a completely online mode of learning. We are completely there for you 24/7 with an online-based resolution forum and compulsory assignments to help you build up your interest and build up your expertise in the subject. Now, what you have to do if you want to avail a flat 20% discount on the criminal drafting course, all you have to do is go on the registration link in the course page and enter this code. I'm also sending this code on the chat box. And you can avail a flat 20% discount on the criminal drafting course. Apart from that, we will also give you a free access to a workshop that's worth rupees 1200. So this could be a workshop of your choice, any of these. It could be about incorporating of a company, basics of M&A and deal making process, basics of GST, or acing the jurisprudence exam. So you can absolutely choose which workshop would you like to attend at Lawctopus, and we'll give it to you for free. Additionally, you will also get a flat 10% off on any other course here at Lawctopus Law School, which you can avail within a year. So you don't have to make a hasty, at the moment decision about other course that you want to avail at Lawctopus Law School. You can take your time, you can decide at your own sweet discourse. And the total value of these bonuses that we are giving and offering to you is more than 4,500 rupees. But I think the most important factor is the attitude sets and the life skill sets that we are providing you with, which is, I don't think, comparable to anything and will last for a lifetime. So if you want to avail the bonus opportunity, you have time till 9:15 p.m. today. You have only 30 minutes to register for the course. You can go on the course page. I'm sending it to you again on the chat box, and you shall be able to take a flat 20% discount on the criminal drafting course along with all the other benefits. I have some questions. Will the recording be available? Absolutely, Deepika. Tomorrow, I will be sending the recording on the emails as well and on the WhatsApp group. I'm sending the link of the WhatsApp group once again. So you can join the WhatsApp group and keep in touch with all the updates, important notifications with regards this webinar and the bonus registration opportunity, of course. Sending it to you once again. Sure, I will be sending the link for the certificate as well again on the WhatsApp group. So if you have a difficulty making a payment or accessing that page, I will be sending it to you again on the WhatsApp group. Yes. Is this a paid certificate? Yes, Shruti. You have to pay 100 rupees and you can avail this certificate. Rahul asks, are all courses valid for 1 year in recorded form? So Rahul, I think you're getting me wrongly. In case you do choose to go for the bonus registration opportunity, you will get 20% off on the criminal drafting course. And alongside, we will give you a coupon of accessing any other course at Lawctopus Law School for a flat 10% discount. But for the other course that you want to take at Lawctopus with a 10% discount, you don't have to make a decision right now. You can decide within 1 year. Yes, I hope I was clear. Adyasa, I think I have already answered this question. I will answer this for you once again. We will be sending you out certificates within 1 week. Can we generate certificates later also? You don't have to generate.